Welcome to this presentation. My hope is that it will be one of many, and I am going to be talking about the BELA Bill in the context of rights. I haven't noticed many people talking about it this way, and I think it's crucially important. The main thing that you need to know on this page is that I have no party political affiliation, and I'm focused mostly on the rights of young people rather than on their parents, and that you are free to use this presentation to make your own presentations and even earn from them. Go ahead, it's on public domain. If you think that these ideas are important to spread and you think they are accurate, then go for it, because I think we don't have very much time to get the word out there about this and to turn it around. I've been studying and interacting with the Basic Education Laws Amendment, known as the BELA Bill, for 7 years now, almost. And in all that time, I've been kind of wondering if I'm not all there for some of the things that I've seen in this bill. And I've tried to confirm them and reality check them. And sometimes my confusions have been cleared up, and sometimes they haven't, and sometimes things have been confirmed, which has been frightening. But a number of my concerns were only confirmed a few days ago, on the 20th of March, the day before Human Rights Day, because the DBE finally got online and responded to what they said was all, but no, some of the written and oral submissions opposing parts of the bill, particularly some that I had watched being presented the week before, and I had a pretty good idea of what was in them, and I watched how that was changed and how that was responded to. So finally, I really have confirmation for some of my perceptions, and I'm now really confident in saying what I'm now going to say, and that still doesn't make it easy to say at all, because it's going to be quite heavily critical. I do offer this input not in order to criticize or blame or shame anybody, but to give us a hope of changing track before this law locks in problematic strategy, because that's what laws do. Laws lock in strategy, and I think that the DBE is making a huge mistake with the strategy that underlies the BELA Bill. We can still turn things around for the good of all South Africa's children, which is what has to be our priority, and that seems to require calling a spade, so I'm going to now proceed to do that issue by issue, and I'm taking one issue today, which is the jailing of parents and the increase in jail time for parents. Let's bear in mind that totalitarian states and monarchies violate or violated human rights all the time. The people at the top simply decided what to do with the people at the bottom, and that's that. Whereas democratic states work hard at making sure that they respect, protect, fulfill and promote all rights for all citizens. And to the extent that they don't do that, they are sliding towards totalitarianism, which is happening in quite a few of the countries of the world at the moment, and we do need to turn that back around. Honestly, it's getting hard to see which South Africa is going to become in the years ahead, because I don't think that we are either right now. I think we're in a bit of a muddy interzone between those two, and it could go either way. I see BELA as a turning point, and what we do or don't do with this particular bill is going to make a very big difference to which way we end up going. Also because an education system shapes the culture of the nation. The nature of the culture of the nation. Great Freudian slip there. Okay, let's go in and do this thing. So, our Constitution gives us detailed information on what has to happen if the state wants to limit the rights of any citizen. It says that you can only make laws that limit the rights of a citizen if that limitation is reasonable and justifiable in a democratic society that is based on human dignity, equality and freedom, and it has to take into account a number of factors to make sure that it does that, so that it's not just tick boxing and lip servicing, but it actually can use this checklist to check if a limitation of rights is appropriate. Firstly, you have to look at the nature of the right. How fundamental is it? What does it affect? What other rights does it affect if you limit that right? How important is it to achieve the thing that you're trying to achieve when you think maybe limiting the right will do that thing? You have to look at the nature and extent of that limitation. How much do you limit it? In what ways in order to achieve that purpose? What is the relation between the limitation and its purpose? And is there any less restrictive way to achieve that purpose that doesn't require you to meddle with people's rights? So just to briefly make that concrete, if we look at the right to liberty and we look at a serial murderer, it's important to stop that person from killing any more people. So that purpose is very important. So we can look at limiting their right to liberty. But how much are we going to limit their right to liberty? We're going to maybe put him in solitary confinement so that he can't kill any of his cellmates. Whereas if we're jailing somebody for something much less severe, we might only put them under house arrest. So all of that kind of consideration has to come in here when we make laws and prescribe minimum and maximum sentences for people in terms of the laws that we make. So now let's have a look at what the BELA Bill has done sentencing parents in the bill, because it's doubled the sentence. But first let's just look at exactly what has to happen. So only when the purpose is truly important enough to justify limiting the enjoyment of a particular right to that extent, and research shows there's no less restrictive way to achieve the purpose, and there's solid evidence that the purpose will actually be achieved by limiting enjoyment of the right, and then the state may limit a person's enjoyment of a particular right, but only up to and not beyond the extent necessary to achieve the purpose. So what should have happened when they decided to increase the sentence for parents in the BELA Bill is that they should have, first of all, so let's look at what they wrote. Before they wrote this, it says, any parent who without just cause and after a written notice from the head of department fails to comply with subsection 1, where it says they must cause a child to go to school, is guilty of an offence and liable on conviction to a fine or imprisonment for a period not exceeding 12 months, or to both a fine and such imprisonment, which is a double of the previous sentence of 6 months. And there was actually a proposal earlier in the BELA Bill process to make it 6 years, and come to that a little bit later. But when they were going to do this, they needed to first consider that the parent's right to liberty is fundamental, and limiting this right impacts the enjoyment of almost all other rights. There's not very much you can do with your rights when you are in jail. The child's right to family care is fundamental and has a huge impact on a child's well-being. And research shows that there's a lot of negative impacts that happen when children's parents get jailed. And one of those negative impacts is a drop in school performance, which must already give us a bit of a red flag that we've got to be extra careful if we're trying to increase the protection of the right to education here and we're jailing a parent. Things might backfire, so let's tread lightly. We'd need to show that the child's overall best interest and enjoyment of all their rights, including the right to education and everything else, will be positively affected by jailing that parent. We'd have to show that less extreme measures that don't interfere with anybody's rights can't make enough difference to school attendance. We'd have to explore those first. And we'd have to show that criminalizing parents has effectively resolved absenteeism somewhere, that this does work to achieve the purpose. And quite importantly, because we're not talking about starting to criminalize parents here, that's already happened in the South African Schools Act a number of years ago. We're looking at increasing the sentence. That's the specific amendment that's being made, so we have to justify specifically that. So we need to look at the research that says, oh, look here, if we double that sentence up to a year, suddenly kids start going to school. We need to show that. Now, what actually did happen? So this is the increased sentence for parents who don't cause a child to attend school, and we'll go into that wording in a little bit more detail because that's also important. But first we're going to look at some other things. So first of all, how does this clause limit the enjoyment of rights, and what are the possible impacts of that? So as we've said, parents have the right to liberty, children have the right to family care, the family also has the right to choose the form of education. Children might suffer a range of impacts, including school failure. And then there's these interesting details. For example, which parent are you going to jail? Because you're going to jail the person responsible for the child attending school, which is actually who isn't responsible, who's co-created a child. You'd have to track down those absentee fathers that are so often part of a family where the child is not attending school. what purpose has been stated for the clause, and who benefits it in a way that it's achieved. Now we can go to the memorandum, which summarizes the BELA Bill and the different clauses, and we can go to the socioeconomic impact report that is supposed to tell us why all of the clauses in the BELA Bill are being put there for what end, and we go there and we look and see what's the purpose that's been stated. But we don't find anything. We find something misleading, which I'll unpack again shortly, which is, it says that the purpose of the sentence is to act as a deterrent for parents who prevent a learner from attending school without just cause, which isn't actually what the law says. But there's no rationale offered anywhere for the actual amendment to increase the sentence. There's a mishmash of explanation in both the memorandum and the SEAS that is kind of covering the whole of clause 2, B, BB, and C. For example, the only sort of concrete thing that's mentioned is burning down schools in Limpopo, which didn't involve parents except the parents who were trying to protect the schools. And in that kind of obfuscation, you have to look and see and spend a bit of time realizing that they haven't ever gotten around to saying we're increasing 6 months to 12 months because it wasn't enough of a deterrent is sort of the only implication, and even that's not clear whether they're referring to this or the other one. What are the relative impacts of achieving or not achieving the purpose compared with the impact of limiting the rights? Well, it doesn't look great here. A number of experts have argued against this amendment, and I'm not going to go into that detail now, but I mean, you can even just look it up. You can see a number of people have protested against this. A number of professors and lawyers have said this shouldn't be happening, right? And given that children whose parents are jailed are at risk of higher school failure, there's no evidence to suggest that this is actually going to support the child's fulfillment of the right to education. Carrying on, less restrictive means, are there any? Well, yeah. Because there's no evidence offered that there's no less restrictive means, because there are so many less restrictive means you can use to increase school attendance. I'm not mad about the idea of truancy officers, but it's been suggested, and that would certainly be a less restrictive and more normal means, and that would create employment opportunities, which South Africa certainly needs. But a lot of the research actually shows that school attendance, in South Africa particularly, is affected by all sorts of things, HIV and all sorts of stuff, but also many, many different poor school conditions. For example, bad relationships with the teacher, corporal punishment, overcrowding, boredom, distance and transport, and horrible buildings and lack of sanitation. All of these things affect school attendance. So it would make a lot of sense for the DBE to focus on first improving school conditions, to see if that helps, how much difference that makes to school attendance, because it's likely to make an enormous difference. And that would result in the fulfillment of rights rather than the limitation of rights. So that's kind of obvious that that should be a first resort, and that should be exhausted, and we should be able to see through research that that's been exhausted, or that these particular cases are not impacted by that. What evidence suggests that limiting the right will reliably achieve the purpose? Well, there isn't been any offered, and significant evidence suggests that it won't actually achieve it. Studies of criminalizing parents have shown that social support works better than criminalization. And what grounds are there to support the specific extent of interference as the correct amount truly needed to achieve the purpose? This is the most important one for this particular amendment, because this amendment is simply changing the amount of time the parent would be able to stay behind bars. So we want to see here, we want to see research showing that the 12-month sentence is more effective in ensuring school attendance than a 6-month sentence. Earlier, as I mentioned earlier, it used to be 6-year sentence, and there was no apparent rationale for this either, just a kind of authoritarian relish, looking forward to be able to punish people because you can. So, what happened in the last 2 weeks that made me really dig my heels in now and say, yeah, what I'm seeing here is what I'm seeing. So a couple of weeks ago, when Section 27 made their official submission, you can watch it on video online. I can put the link in the comments of this video. Public Law Center Section 27 said that in relation to the criminalization of parents who failed to cause their children to attend school, Section 27 notes that this is ineffective. It is against the best interests of the child, which is supposed to be the number one priority according to our law. We always have to look at the best interests of the child as the main concern. It's an obligation. And this law has the potential to disproportionately prejudice mothers in particular, because it's often mothers who are left behind who are really caring for the child and doing their best, and then they don't manage, and then they get punished for that. And Section 27 recommended that these kinds of criminal sanctions on parents be completely removed. Then they added, yeah, okay, if you won't remove them, then in the event that they are kept, we note that these have to be made subject to certain considerations to make sure that the best interests of the child are protected. So if you're going to keep this law, at least, please make it more detailed, make it work better, so that we can be sure that it's not going to be abusive. It's going to actually do what it's supposed to do in a human rights aligned way. And the reply that blew me away 2 days ago was that the DBE just, the amendment may not be removed. Why? To give effect to compulsory education. Kind of vague response. No undertaking to add any safeguards. Yeah, whatever. We're just going to do this. Which is just, oh my word. Yeah. Okay, let's just keep moving on, right? To deprive a child of their parent in order to tick a bureaucratic box around the form of education that the child receives is unconscionable. Because as I'm going to point out in a moment, this clause doesn't apply to people who are preventing their child from getting an education. This clause only applies to people who are failing to cause their child to attend a particular school specifically, which is just a form of education. It's not education itself. Even the threat of jail time for a parent is traumatizing to the child, and during these 7 years I've watched a number of children actually get terrified when they hear about this in the BELA Bill. And there's a number of families of my acquaintance who've actually avoided involvement in the hearings. They're not speaking up for themselves. They're not speaking out against this bill because they are frightened that it's just going to get shoved through, and maybe they're right because it looks like it's being shoved through. And they don't want to be targets and have vengeance wreaked upon them by the DBE once the bill passes into law. That's the kind of relationship the DBE is creating with this bill, which is not in any way constructive for what needs to happen for education in South Africa. Right, so aiming to use this clause as a deterrent without ever actually jailing anyone, that's the one comfort people are hoping for, but that's just going to create more contempt for the state and undermine respect for the law even more than already is the case, growing in South Africa, not useful. On the other hand, using this clause to arrest a small number of parents to set an example will violate the rights of the families affected and will intimidate other families. And I'm using the word intimidate specifically because this is not preventing people from committing a crime, it's preventing them from looking at the best interests of their child, because it's going to get them to force their children. I'm already seeing people on chat groups going, oh my gosh, have I got to really force my child to go back to the place that was so bad for them? So then the DBE is accommodated in their failures because they can postpone and avoid the obligation to improve the quality of public education provision, because they can just force people to go there and accept whatever is provided. So a deterrent in its proper role in a law prevents people from doing something that they ought not to do. Right? That's a proper deterrent. Whereas when you use a so-called deterrent to stop people doing what they should do and fulfilling their rights, that's called intimidation, and that's actually a crime. And this would be preventing the child from enjoying a number of their rights, including but not limited to the right to use academic freedom, to fulfill your right to education in personally optimal ways, Some people don't learn best in school, or some people learn best in totally different types of schools that aren't licensed by the DBE at the moment, for example. Their right to safety and freedom from violence. I helped collect loads of responses from young people back in 2017 on why they didn't want to be forced back into school, and a huge number of them had left because of bullying, because of corporal punishment, and because of various kinds of abuse that they couldn't escape. They were not safe, and this would force them back into those environments where they are not safe. I mean, gosh, the sexual assault and abuse that's going on. And remember that it's not only the direct victims in any classroom who are actually traumatized and suffer and need to go for therapy. It is anybody who witnesses that, anybody who fears it happening to them. When we look at the violence in South African society, if you actually know a little bit about the cycle of violence and the effects of trauma, what's happening in our public school classrooms, and then there's no trauma recovery for these kids, and then you want to try and prevent GBV and violent crime, look right there for the seed you've planted. What you reap, you shall sow. Then another right is the right to disability support, because again, many of those kids that sent their responses actually were maybe undiagnosed or diagnosed with various different kinds of learning styles, or different neurodivergent types, or various levels of disability, and they were generally persecuted, or at least like not accommodated, not helped. And coming out enabled them to thrive, and they'd be forced back in against that right. So we've got to consider this quote by Professor Visser from the University of Pretoria, 2007, but it's still absolutely true and always will be, that obliging parents to send their children to poor quality schools makes a mockery of what compulsory education is all about. This is not what it's meant to be. Let's look at that in more detail. Okay, I've opened a link there instead of the next slide. I'm just going. Right. So there's a number of links in this presentation, and I'll pop them in the description of the video, so that I want you to be able to go and reality check this. If you think I'm talking nonsense, I want you to be able to go and look it all up for yourself. So the next thing that we have to look at is where I said there's an important difference. We have to look at the wording here, that the memorandum said that this applies to the parent who prevents a learner from attending school. But that's not what the law says. The law says it's about a failure to cause a learner to attend school, and it's not a small difference. Cause and prevent are actually opposite concepts. So a parent who prevents attendance is more likely to be actually interfering with the child's rights. Not definitely. They might not be preventing attendance because they don't want the child to get an education, but they could be actively preventing attendance because they believe that it's not a good idea for the child to go, or whatever it might be, right? But a parent who fails to cause the learner to attend might be interfering. They might just be negligently letting the child stay home and just making it kind of, they just don't bother to provide transport, for example, when the child really wants to go, in which case that would be a case for the state to interfere. That would be legitimate. But on the other hand, they might be protecting the learner's rights. If you look at those young people I was speaking about a minute ago, where the parent acknowledged that it wasn't in the child's best interests to go. And so they allow them to choose a different way to fulfill their right to education. So depending on the potential dangers and impacts on the learner of attending school, the parent who fails to cause them to go may be actually fulfilling their duty to consider the child's best interest and put that first. And in those cases where the parent fails to cause the learner to go, and it would be better if they did cause the learner to go or support the learner to go, they may not be actually violating the child's rights or neglecting the child's rights. They might be trying very hard to get the child to go, but they might not be managing because they're struggling, because they're lacking capacity and they need support in some way. Have you seen the distances some kids are forced to travel to get to school? Some of them going without breakfast, and then they have to walk, and parents sometimes have to leave the house before the children even wake up in order to travel to their jobs. Sometimes it's just not within a parent's ability to get a child to school, and criminalizing them doesn't make the difference. Social support does. Now, what happens when that memorandum says this is about preventing the learner from attending school? We're going to punish those parents who prevent their kids from going to school. That influences the decision makers to see this clause as more reasonable than otherwise. Subliminally, you notice, oh, that parent's interfering. And at some public hearings, only the memorandum was made available. So the people at those hearings had no way to check that it doesn't say it prevents. It actually says fails to cause. So what is really going on with this clause? Without actually anything accurate in the memorandum or the SEAS, I went looking in the media statements and verbal statements by the DBE at public events to see, okay, so what's actually the rationale for this? What have they got in their minds? And some of the things they say might line up with them appropriately interfering when there's educational abuse or neglect. But here's at least two intentions, which I strongly argue are failures to cause due to lack of capacity that requires support, rather than cases of prevention of attendance due to actual neglect or abuse of the right to education. The first one gets repeated and repeated. They want to jail parents who are getting their children to beg at traffic lights. Okay? Instead of going to school. We've got to look at a context here, right? The DBE is an education department that is politically aligned. The policy and the higher roles are all put in place by the party that has the majority in the country at the moment, which is also the party responsible for what else is happening in the country. And we have got an increasing and horrific number of children dying, going, through incredible malnutrition and starvation and not living anymore because of lack of food. And if that parent has no other option, because often school feeding schemes fail as well, I mean, let's face it, if you've got a starving child and there's a meal available at the school and it's reliable, you're not going to have your child begging at the traffic lights. You're going to have your child at school so they can get fed for the day. So, bearing in mind this context, you're going to jail those parents. I mean, what's that going to do? Oh, yeah, that's going to be convenient for the ruling party, because suddenly you're not seeing children begging at traffic lights anymore. Makes it look as if there isn't such a poverty problem, whereas actually those children just can't even get to the traffic lights and they're at home now dead. Thank you. We've definitely improved their right to education. If I sound a little bitter, that's also because of my time supporting my mom and her work with street kids earlier in my life. I've seen this reality up close and personal, and I'd really love it if some of the seniors in the DBE went and had a look at this reality up close and personal instead of from the viewpoint of their privileged prejudice. Okay, moving on. Calm down, Je'anna. Okay. Right. This is also what really got to me when it was reiterated a couple of days ago at this presentation, as if it was a real justification. The other one that came up is parents struggling with substance abuse problems. Now, this is again something that it's easy to make a moral judgment about when you don't have the problem, but there's an enormous amount of influence of unemployment, poverty, and trauma involved in addiction. And if you're going to take a parent who loves their child and is doing their darndest to support their child and trying to get them to school and failing because you're too bubbleless sometimes, arrest is not an option. It's not going to help. Social support is going to help. So, it breaks my heart to think that these are supposed to be optimal strategies. So I'm going to take a very deep breath here, because what I have to say next is extreme, and I believe it's necessary. Right. I believe it's necessary to say this, and that it's accurate to say this, and that it needs to be said. A reminder again that I do not say this to judge or to shame or to blame. but unless we face this, we're not going to change this. So all of this that I've just been talking about suggests that the DBE either does not understand or does not respect or care about the difference between the state's obligation to protect the right to education by appropriately interfering when there are cases of bona fide interference with the right, like I've mentioned in other places. Sexist parent saying girls can't get educated, or disabled kids not getting education, for example. There, the state has the obligation to interfere. That's valid, it's correct, it's human rights aligned. But there's a world of difference between doing that and using your power to perpetrate human rights abuses on already vulnerable victims as an expression of your privileged and arrogant authoritarian entitlement and prejudice, jailing people because you can. This is evidence of a very serious problem within overall DBE culture, and it goes far beyond discussions of the BELA Bill. Authoritarian attitudes that normalize severely abusive behavior cannot be allowed to provide a foundation for any state department or any legislation. As pointed out, in fact this is pointed out in the start of a longer presentation from which I've taken this excerpt to re-record, it is actually more critical for the Department of Basic Education to deeply embody human rights as best practice than for any other state department, because they do shape the culture of the nation, and they are supposed to be teaching children about their rights through giving them a lived experience of having their rights respected. Let's also notice that this authoritarian kind of attitude is what is driving the worst instances of so-called corporal punishment, which are actually just assault, because teachers can punch people who have failed to pass a test that they were trying to pass with all their might. As above, so below. No wonder it's so hard to get rid of corporal punishment on the ground when the DBE is modeling this attitude even right up to the laws that it makes. And how? The severe lack of empathy embodied here suggests that it may even be advisable to consider listing a number of DBE policymakers with the Department of Social Development as people unsuitable to work with children. If you can't tell the difference between appropriate discipline and bullying, you shouldn't be in this realm. This is a follow-on video from the first video about the clause 2b of the BELA Bill, criminalizing parents and extending the jail time recommended in the BELA Bill. This is a brief video suggesting solutions for clause 2b, because there's no point criticizing something without at least making an attempt to fix it, right? So, just to recap, we said that only when the purpose of limiting a right is really important enough to justify doing that to a particular extent, and we can see that there's no less restrictive way to achieve the purpose, and there's solid evidence that the purpose will be achieved by limiting enjoyment of the right, then the state may limit a person's enjoyment of a particular right up to and not beyond the extent necessary to achieve that purpose. And we looked at the fact that jailing parents doesn't do this, and extending the jail time for parents absolutely doesn't do this. So it's really not okay to double the jail sentence simply because the shorter sentence didn't work, when there's no evidence to suggest that a longer sentence will work either, because the wrong factors are being addressed. Doubling down on something that's not working isn't useful. And this is something to consider regarding other parts of the DBE's strategy as well, again beyond the scope of today's presentation. I have even seen an essay suggesting that the interaction pattern between the DBE and the public is increasingly similar to that of abusive GBV relationships, gaslighting included. And what I suggest here suggests that that's spot on. But this doesn't mean that the people involved are evil. It's a very tricky situation. Most bullies are people who are struggling with self-esteem, and remember that the DBE isn't a person, but it's almost like a person in its own right, and the people who are inside there are kind of trapped in that structure and that dynamic. The DBE as a whole is under enormous amount of political pressure from above and below, from international sources, from human rights treaties, and sustainable development goals, and from below, from the public, and there's just and from within there's conflict. So it's not surprising that they're using BELA to try and make things manageable by cutting things down to size and trying to make them go away. I've got a video where I talk about this in a bit more detail. Trying to not have to deal with anything they don't have to deal with, instead of persevering to find real solutions. To even seem to cope, they kind of have to centralize power and shut down all opposition. But it's not really what works. It's not going to what's going to help. It would be better to negotiate a new deal altogether. But it's hard to be vulnerable and admit you're not coping, and it's easier to play clever political games and throw your weight around. But none of that helps the children of South Africa. The important thing for me is that law locks in strategy, and the strategy locked in by BELA is abusive and self-defeating. I believe BELA needs to start over with different foundations, not least because the DBE by now has whipped up such fear and rage about BELA that letting it go through in any form will be inflammatory. And perhaps if there's a clause or two somewhere that not one person has opposed, maybe that could go through. But let's try something brave and new, why don't we? So here's my proposed solution for BELA. Firstly, let us amend the Schools Act, because the Schools Act also says cause, and that the parent must cause the child to attend, and you can't cause somebody else to do something without coercing and abusing them. It's just not possible. You can't cause people to do things. It's bad wording. You want to support them, perhaps. Every parent should support the child in fulfilling their right to education rather than attending school, because there's also many ways to fulfill your right to education, and those ways are increasing every day. So what we want is we want to see wording that specifically invokes the DBE's obligation to protect the right to education by interfering with parents who prevent the child from fulfilling their right to education. It needs to be prevent, and it needs to be fulfilling the right to education. We no longer want to be penalizing parents who fail to cause a child to attend school. That is not human rights aligned, and that is open for abuse. So that wording, prevent a child from fulfilling their right to education, would absolutely enable human rights aligned state interference in cases of bona fide educational abuse and neglect, in order to protect the child's right to education, without incentivizing bureaucratic or opportunistic political abuse, and not incentivizing the DBE to further neglect the obligation to improve public school conditions, which is the real worry for me also if BELA goes through. I just can't see what incentive they'll have left to really do due diligence for those who are invisible and voiceless. Remove the change in penalty. It's pointless. It's silly. You can keep the one that's already in the SASA. It's enough, as long as it only applies to parents who prevent the child from fulfilling their right to education. Address other clauses that are problematic, because this is just one of many that have been flagged, and I hope to speak about more of them in the next little while. It's honestly best to scrap the whole bill and start over, but I know that they don't want to do that, and I can understand that, after 7 years it's very hard to do that. They've really got a lot of sunk costs, and sunk costs are always a bad reason to persevere with a bad plan. But hey, we are human. So if necessary, just strip that bill down to only those clauses that are both urgent, truly necessary, and have emerged from this process as completely uncontested. But I don't know how many of those there are, which in itself should give us pause. So then, on the other hand, the other half of this is proposed solution for SA education, in terms of what BELA is or should be trying to fix. So research links student empowerment and collaborative discipline with dropout reduction and improved classroom culture. Aha, wonderful. So how about the DBE partners with experts and practitioners to implement and extend the plans for the learner representative councils that haven't been rolled out everywhere yet, and other structures for active learner participation in school governance, so that learners themselves are able to take ownership and collaborate in improving school conditions, which is going to increase attendance. There's just a couple of articles that you can explore if you want to, if you're not sure what I'm talking about there. There's plenty that you can find. The more that human rights are protected and respected and promoted and embodied and fulfilled, the more people actually collaborate and behave better and things like that. Create increased participation opportunities for parents, teachers, community members, local businesses and other stakeholders to be able to collaborate in improving school conditions and providing support for vulnerable families. There's actually so much we can do when we harness South Africa's capacity for Ubuntu, which is still there. It's totally there. And it takes a village, right? It takes a village to raise a child. It takes a village to run a school. This is the opposite strategy to the one that's in BELA right now. But it's really the only thing that's going to work. Empower and encourage microschools, informal education support initiatives and home educating families to share their secrets of success, because there's been a lot of incubation and innovation going on. And take inspiration from flexible and mobile options such as traveling teachers provided to nomadic groups in some countries who go where the children go instead of expecting the children to stop and come to them. We need to creatively innovate and revitalize the South African education landscape so that all learners have access to options that support them in fulfilling their right to education in personally optimal ways, regardless of the challenges to their life circumstances. Things are tough. We can't pretend that petrol's suddenly going to get cheaper or that food's suddenly going to become easier to come by. So we need to find ways to work with these conditions instead of trying to punish them out of existing. Children currently forced to choose between starvation and education shouldn't have to choose between these things. They should have educational support that comes to where they are, rather than having their last source of care removed from them. Right, where does that leave us? What are we going to do about it? So there's a few days left. I'm sending this out on the 24th of March 2024, and there's one province left that's still listening. The rest are all finished, but here are all the details you need to send your thoughts to that province. Please be respectful, specific and accurate so that your submission will not be discarded, because you are writing to the people who did not draft the bill and do have the power to change it. So, talk straight, but talk politely. First, before you do that, if you hadn't already thought of doing that, if you're doing it on the basis of this presentation, then absolutely you need to check out whether you think this presentation makes sense. If you think it's misinformation, I'm going to put the links in the description. You can go and have a look. And either way, maybe you're only going to view this video when it's too late to have any impact, in which case please go ahead and learn more about your rights. You weren't educated in them. Most people have no clue what rights actually are. And children, support them in learning their rights, and support them in learning their rights by giving them a rights respecting environment, because it's not what we learn about, we learn what we live, and we need to change what South Africa's children are living. Thank you so much for watching and for your like or dislike. It's your right to dislike this video and disagree, but please do share it. Let's get this conversation going on, and please do use the comments. I'd love to know your thoughts, whether you agree or you don't agree. Let's develop each other's thinking together, because that's also how democracy works, and that's also how we avoid totalitarianism, is not creating echo chambers, but actually exposing ourselves to different points of view. And on that topic, I hope to live long enough to be back with more videos on closely related topics very soon, so watch the space. I can't guarantee you that subscribing will help you, because it may or may not be on the same channel. But yeah, let's do this, people. Let's make a better future. Thank you.